The expansion of wind energy in South Australia coincided with one of the worst droughts in South Australia's history. It was experienced here. 07, 08, 09 were dreadful seasons. Late starts and early finishes, and that put farming and grazing people in South Australia and in these communities under pressure. And that's a pressure that you people should well understand. And vulnerable as they were, they looked at the $7,000 or $8,000 per turbine as an opportunity to obtain some income beyond what the wife was earning at the district hospital, because nothing else was coming in. Here was some cash money. The overdraft needed to be serviced, and here was a way of satisfying that. Vulnerable people, right? Of course, they're not aware of the noise issue, so more and more contracts were signed and entered at Waterloo, at the various stages of Hallett, and other places. Unaware, people unaware of what was coming. In June 2009, the story starts. It starts with people like Andy Thomas, and he was a gentleman who was lambasted at a public meeting by an EPA officer who used the same argument. This man is only jealous because he's not getting any income. He's not getting the income that his neighbours are getting. Now that started or triggered some events. The EPA received complaints from a solicitor and doctor who were present at that meeting, who saw the behaviour of an EPA officer as abominable. They complained to the chief of the EPA in South Australia, following which the paper trail dries a little, so it's hard to connect the two, but the relationship was so close in time. Shortly afterwards, further noise testing was carried out at Andy Thomas's house, the man who had raised his complaint and had been ridiculed publicly. Following that, they found an issue in the noise being generated by turbines, a characteristic called tonality. And Stephen Cooper's territory, but effectively it means that the noise is more annoying. So the graphs that you saw before about low frequency noise and the thumping of the turbine blade is referred to as tonality. And that adds a 5 decibel penalty to the measured or predicted noise levels at a receptor location. And I pause to notice the language. I work in language, I'm a barrister. You are receptor locations. You're not farmers, you're not householders, you're not residents, you're not people, you are receptor locations. You follow that? Right? That's the regard, or rather the contempt in which you are held by the authorities who are meant to protect you. The Environmental Protection Authority is set up with a statutory obligation to you people to protect you from excessive noise. They haven't done it in South Australia. Now, the measurements demonstrated that they were in non-compliance at Mount Bryan, at that stage of their wind farm, and that had some consequences. One, it allowed the full court of the Supreme Court in South Australia to allow an appeal, in which I was taking part, against the Hallett 3 wind farm, which was the planning case that we were challenging. That case has been remitted to the ERD court for further hearing on the issue of noise, and that's another story for another day. Now, after June 2009, communities became aware of the problem. And the problem of noise was the hot topic amongst people who were either hosts or particularly those neighbouring proposed wind farms. And that's what led to the planning appeal I mentioned a moment ago, because people were concerned about it. And opposition began to build. Unfortunately, in the meantime, the wind farm, where you saw some data projected a while ago, called Waterloo, Napoleon met his Waterloo. Well, this is Waterloo, and it is a planning disaster. The magnitude of it equals Warburg in Victoria and the other places that John Madigan talked about, because there were no planning controls applied or properly applied in relation to the receptor locations, read people, and there will be 10, maybe a dozen, or perhaps as many as 20 homes abandoned because they located 3 megawatt Vesta turbines, enormous industrial machines, within a kilometre of at least a dozen homes. And these are substantial homes. One of them a brand new place, 2.5 kilometres away, and this woman is driven mad. Her story's been documented. She has appeared on an ABC State Line episode, and measurements and so on have been conducted at her home. This woman's not crazy. The measurements back her up. What you saw in the infrasound and the low frequency measurements entirely support her experience and the experience of many, many others. Now, I hope I've opened your eyes to what is the tragedy. What your options are, I'll talk about in a moment. But so far, what I've seen in New South Wales is identical to what's happened in South Australia. The authorities have failed in South Australia, and they will fail in New South Wales because of the combination of interests. The EPA and the planning authorities have been co-opted by wind energy groups. Co-opted by them. Conspiracy is not the proper word. I shouldn't use conspiracy. As a lawyer, I shouldn't refer to that concept. It has other implications. You can call it what you like. The EPA are culpable in all of this. Watch them. Bring them to account. That's one of the things you can do. Stephen Cooper has identified the problems with the EPA guidelines. He's gone into some detail to attack the South Australian guidelines, and rightly so. Rightly so. Right. Now the EPA in South Australia has these responsibilities, as does yours here. It should set up the standards. And the standards are guidelines and criteria, for example, for policies. It should monitor the implementation of those standards, and it should enforce them. Well, it's done none of that in South Australia. None of that. The guidelines were written by a firm called Sonus. Go to the website and watch Sonus's bragging rights, I guess you'd call it, about the guidelines which it drafted and which were amended to increase the base DBA level from 35 to 40. When they found that the turbines wouldn't satisfy a 35 DBA limit, you don't like the rule, what do? You change the rule. The rule got changed. No justification for it at all, and it was about the numbers at a receptor location. Not about people at all. Now, I think I've spoken enough about the tragedy. I think the sombre look that I see around this room, as if I've come from some dark foreign place and told you something you didn't want to hear. Well, it sounds biblical. Now, what are you going to do about it? What can a community like you do about it? Well, your neighbours are hosts. The people that are concerned about it at the moment are those who are worried about turbines being put on their neighbours' property. Well, I'm here to warn the hosts. I've written for this group and provided to Sam and Charlie a document with some 36 pages. Now, I've no need to go into the content of that document, save to highlight a few aspects of it. The document is for the use, and I understand, for the benefit and the purposes of this group, and to follow on from this meeting. And it outlines in clear detail the rights that private citizens still retain to a night's sleep. The English law, for 3 centuries, the English common law has protected the man in his home and in his bed from nuisance, from noise. Injunctions are available to prevent the source of the noise, and they've been granted for at least 3 centuries, but they firmed up in the 19th century, particularly as Victorian England industrialised. The railways were being built. Stables were needed to house the horses that were there to build the railways in and around industrialising Britain. And those stables had a lot of horses in them, and those horses made a lot of noise. And they made noise at night time when gentlemen were retiring and hoping to sleep. The paper that I've provided, the opinion that I've given, contains about a dozen cases about stables, including cases in South Australia into the 20th century. Horses made a lot of noise. Now, this group might have forgotten it, although I see some faces that would know a lot about horses. They saddled them up on frosty mornings and they hooked up teams if they were ploughing out on the flat country. They know about horses. Noisy. Put them too close to people, you'll interfere with their sleep. Simple rule, remove the horse. Let the man sleep. You can substitute wind turbine for horse and stables for wind farms and come up with the self-same result. A man is entitled to sleep in his own bed at night. Now, the injunction is available to shut these things down at night, but you're one step back. What you're dealing with are wind farms that are proposed, yet to be constructed. Well, the same remedy is available to you. You can bring proceedings against the hosts to obtain an injunction to prevent these things being constructed. That's the rub from this document that's been provided to your leaders here. And I need to go into the detail, but that's enough. The consequences of noise nuisance will be the diminution in the value of the property that the person has to abandon. So if you think about the 20 or 30 that walked out of homes at Walker, the 10 or 20 that will walk out of homes at Waterloo, and the many others that will continue to be affected by turbine noise, those houses are effectively being stolen from people. There's something bitterly unjust about a system that rewards the turbine host somewhere between $7,000 to $10,000 per turbine, although, funnily enough, since opposition began, those numbers are starting to increase. They're looking to entice people to sign the contracts, and I'll spend a moment on, in a moment I'll talk a little bit about the contracts, because there are some consequences in them for the turbine hosts. Anybody in this room considering signing one?
One just walked out the door a moment ago.
Did he?
It was too hot for him.
Did he?
Yes.
All right, well, he might have stuck around because he could have saved himself some millions down the track. Sorry. Excuse me. Back on track. Now, the consequence of stealing somebody's house is that you'll have to pay them back. And that's what the law of nuisance and private rights are all about. If you drive me from my home, if you devalue my property, and I can't live in it, then you'll compensate me for it. You'll pay. Now, communities. We'll come back to communities. Having sat down and drafted this opinion, which was literally a review of common law rights, it spans 2 centuries, and it brings us up to the modern day. I'm astonished, or would be astonished if it wasn't for my background, that nobody has taken a turbine host to task today. The case was instituted in the UK in 2011. The Davis case, some people are nodding, they know about it. It was a case in common law nuisance. They resulted on the doorstep of the court, and I understand that an undisclosed settlement was paid, effectively for stealing somebody's house. Now, as yet, nobody has taken that step, but I can tell you now I'm involved in a case where the step will be taken very shortly. Very shortly. All that is required is for one of you to take that same step. The evidence can be marshalled with ease. Stephen Cooper's got half of it. You've seen some of it. That supports the experience, the tragic experience of the people in South Australia and Victoria and elsewhere. And that experience is in itself evidence. You dragged in 30 people from Warborough, 20 from Waterloo, and put them in a courtroom to talk about the loss and the suffering. It will support a claim to obtain an injunction against any wind farm being proposed, and anybody that's troubled by these things sufficiently to disturb their sleep, they are entitled to an injunction as well. Now, this is where it starts to get legal, and I won't spend much time on it. The hosts have signed contracts, and they are the most one-sided documents that you will ever see. You'll be surprised to see them printed on both sides of the page on occasion. You sign up for 25 years. Most of them are in the form of a licence. The 25 years generally has two options, again 25-year terms, so 75 years. Hands up who's older than 75 years here today. Any 75-year-olds? Somebody's close. This man, and with a twinkle in his father's eye, hypothetically, when his father signed the contract, which he's still suffering, 74 years later. That's what we're talking about. We're talking about 3 generations. 3 generations. Now, in that contract, you've already signed away your rights to live in your home. You've already done that. Part of the agreement is that the licence fee or price, or however it's so defined, is deemed to have compensated you for any annoyance or nuisance created by noise. Deemed. So whatever you get is it. You can't be heard to complain about noise, and funnily enough, that's why the hosts don't complain. It's a pretty strong reason to not complain, but it gets worse. The gag clause, or confidentiality clause, means that they can't show you the contract once they've signed it. It can only be shared with their legal representatives. It's not that the lawyer could tell them they've got many rights. There's not much left. They're duly compensated for noise and they've been paid for that. So forget about complaining about noise. If they took steps to challenge the issue of noise, or took any other step to bring an outside agent that might shut those turbines down, many of these contracts have machinery to this effect. If for any reason, negligence or otherwise, the turbines do not operate, and that's caused by any action of the host, any action, then the turbine host is liable to pay as liquidated damages, so a certain sum, the entire value that could have been obtained from that turbine for the life of the licence. And if anybody's seen one of these contracts, have a look out for that clause. Now, you haven't heard from hosts complaining about it? Not to date. I've met and heard quite a few that complain privately. They shrug their shoulders. Well, what can I do? There's a rude word usually injected about that point. Well, mate, you're... Now, that's what you're up against. You've got a community where a few are obtaining a benefit at the expense of the many. They're stealing your houses, people. They are going to ruin your lifestyle. What John Madigan said about empathy, I want to finish on that note. Something happened to our country. I can't put my finger on what it was or just when it occurred. How is it that a community of fine people like you could get to this point? What happened? Did we get greedy? Are we stupid? What sin was it that we committed to allow communities like you to be punished for it? Now, it's a pretty sobering thought, but that's what's coming. The people that should be protecting you are not. They have no empathy with you because you are receptor locations. All right? Receptor location. You'll be number 42 on a map, a red dot. And, well, that house is compliant. So everything's tickety-boo at receptor location 42. All right? That's what it's down to. Something went wrong with this country. It's up to you to take it up to the turbine hosts, the EPA, your planning authority, and the parliamentarians, the people that write the laws, because there's a perversity in all of this. There's a bucket load of money shoveled out of Canberra in the form of renewable energy credits. No conditions attached to them. No requirement to satisfy individual receptor locations. Nothing, okay? The money goes out the door. The state planning authorities, they look great by solving the world's problems of climate change, by driving up in a Prius, putting on the hard hat, there's a wind turbine, problem solved, we can all go home. The state governments don't spend a cent of their own money on this, okay? Peanuts. Something's wrong with that picture. The state governments will tell you that they are simply implementing Commonwealth government policy. We're told to do it, so we just have to get on and do it. The feds say, well, the planning issue and location and siting of these things and EPAs, that's a state issue. So if ever there was a perverse example of what a failed experiment of federation is, this is it. Now, you're members of a community, you're members of a state. You've got a voice, say something. Talk to these people. You're lucky that you've got people like John Madigan and Nick Xenophon, and soon to be a few others, on your side. Good men. Good men. And that's all it takes to prevent what is and could be for you a tyranny. Thank you.